Is Elisa, and today I'm going to be interviewing Mike Chastaine from the Chastaine Law Office about the 10 myths about criminal defense. Welcome, Mike.
Well, thanks for having me.
You're so welcome. We did a survey with some of our clients about what they feel like the myths are or misnomers about being charged with a crime. One of the very first ones, Mike, is that a lot of people think it's only a minor crime and it's no big deal.
Well, and that is a huge myth. There is no such thing as a minor crime, even if it's only a misdemeanor. Although a lot of times people are confused and think that a particular crime is a misdemeanor when it's actually, in fact, a felony and can be charged as a felony. So we take the position that there is no such thing as a minor crime, because even a misdemeanor can impact your job, a professional license, it can cause you to be incarcerated, it can cause you to lose valuable constitutional rights, it can cause you to lose a job, it can cause you to have to pay large fines. So there's lots of reasons why there is no such thing as a minor crime.
Well, it sounds like being charged with a crime, whether it's a misdemeanor or not, that there are a lot of ramifications that are very serious for one's life.
Well, absolutely. We recently had a person in the military who was charged with a DUI, and that could actually end their military career. So there really is no such thing as a minor crime. Every criminal offense needs to be taken very, very seriously. And to understand that the government, the state or the district attorney, has put resources into convicting you. Why? Because they don't think it's a minor crime. So they're going to put all of their resources towards trying to get you convicted of whatever they've charged you with. So you need to take it very seriously, and part of taking that seriously is making sure that you have a good defense team on your side.
Well, that leads us right into the next myth we have. Number 2 is, I can handle this on my own.
Well, that's a huge misnomer and a common mistake that people make. Criminal law in particular is a very specialized practice. The laws change. Matter of fact, they change pretty much every year. And there are specialties that people engage in. So people have focuses on DUI types of cases, on sex cases, on domestic violence type of cases. And the important thing to understand is that the district attorney has whole units for that. So they have a unit of people who only prosecute DUIs. They have a whole unit of only people who prosecute domestic violence cases. They have a whole unit on people who only prosecute folks that are accused of sex crimes. They specialize, and it's really important that you have an attorney who understands the nuances of the case and who also has a focus on those particular offenses. So the idea that you're going to go in there against a trained, skilled lawyer, it's a big mistake. And it's also really important to understand that the judges are not going to give you any slack. They're not going to feel like they should cut you a break simply because you made the decision to represent yourself. As a matter of fact, they're going to feel like you really don't know what you're doing, and sometimes the penalties are worse simply because you are not represented by somebody.
So it can work at the opposite of being in your favor, trying to do it on your own.
Absolutely. The court wants you to have an attorney so that they have someone that they can interface with. What most people don't recognize, if you go into a courtroom, there's a wall that separates half of the courtroom. It separates the audience from the front part of the courtroom. It's usually about waist high. If you don't have a bar card, you don't get to go on the other side of the wall, the side of the wall in which the district attorney is on, the side of the wall in which the court is on. Now, where do you think everything happens? It all happens on that side of the wall. If you were pro per representing yourself, you're stuck on the back side of the wall, which means you really are not going to have the opportunity to negotiate with the district attorney, to go in conference with the judge. You really are putting yourself at a huge disadvantage by not having legal counsel.
Well, let's talk about legal counsel in particular, because this is another one of the myths, and that is all attorneys are the same.
Well, again, that's a huge misnomer. The commonality between all lawyers is that they have passed the bar and they have a bar card. But after that, they're not necessarily the same. There's a lot of lawyers who their focus of their practice is personal injury, their focus of their practice is bankruptcy, and occasionally when someone walks into their office, they'll take a criminal case from time to time. Well, that's like asking a podiatrist to do brain surgery. They're both doctors, but
Just wrong end.
It's sort of the wrong end. You don't want your foot doctor working on your brain. You want someone whose practice is focused on criminal defense. In the Chastaine Law Office, that's all we do. We only do criminal defense and things that are directly related to that, like licensing issues. So it's really important that you have a lawyer that not only has a focus on criminal defense, maybe exclusively handles criminal defense, but also has a focus on the type of crime that you are charged with. As I said earlier, the district attorney's office is broken up into teams that only prosecute domestic violence or only prosecute DUIs. You want a lawyer who is at least as well trained as they are and has a focus on the area in which you're concerned.
Well, I would want that for sure. Thank you for explaining that, Mike. Okay, another myth here is that an attorney only helps me when I go to court. Most people think that that's, maybe it's from TV, but that's where all the action happens, is in the courtroom. Could you shed some light on where most of the action actually does occur?
Well, like any law practice, the work actually happens well before you get into court. Now, certainly TV has dramatized that's where the action occurs, and certainly when there's a trial going on, that's where a lot of the things will happen. But it is the groundwork that is being laid before you get to court. In our office, oftentimes we'll have communicated with the district attorney before we get to court and have resolved the case by talking to them and negotiating on your behalf, so that when we get to court, it's simply a formality of going through the process of resolving the case. But the vast majority of the work is done behind the scenes, before you get to court, reviewing the reports, doing the investigation, getting your team in place, and figuring out a strategy that will best suit the goals that you have in that particular case.
Okay, that makes sense. All right, another one here is, and this one really, being here at the Chastaine Law Office, I hear this from people just calling us on the phone, is that I am innocent, so I don't need an attorney. I mean, isn't that what we're taught, is that it's all, that we're innocent until proven guilty?
Well, it is true that the Constitution says that you are innocent until you're proven guilty, but it's the innocent person who absolutely needs a lawyer. Understand that if you've been arrested and if you've been charged with a crime, the police think you're guilty, the district attorney thinks you're guilty, the court probably thinks you're guilty, and everybody else associated with the court. There's this old saying that, where there's smoke, there's fire. You wouldn't have been charged if you weren't guilty. That, in fact, is not true. Innocent people get charged a lot, and it is the duty of the defense lawyers to show that person was misidentified or didn't in fact do the crime, or the person who's accusing them is lying. The criminal defense is an adversarial system. The district attorney is not looking out for your best interest. The only person in that courtroom who looks out for your best interest is your lawyer. And it is very important that they advocate strongly on your behalf, especially if you didn't do it. In particular, you need to make sure that they have the investigation that needs to be done. The people that can prove your innocence to have to be interviewed, and the facts have to be teased out to show that in fact you didn't commit the crime, or maybe the crime didn't even occur. We handle cases in which there's child custody battles, and one of the parents either directly or inadvertently will suggest to the child that they can make daddy go away if they only said daddy touched them, and all of a sudden, lo and behold, the kid is saying that daddy touched him, when in fact it's not true. Those are very difficult types of cases to defend, but in fact, innocent people do go to prison, and there's scores of examples of that. So being innocent is absolutely a time where you need the best counsel that you can obtain.
What about the inverse of that, Mike? When somebody is guilty and they'd be like, okay, I'm guilty, I did it, I don't need an attorney, and, they just accept that. Why is that a bad idea?
Well, that's a bad idea because that's assuming that everyone is going to be treated exactly the same. And in fact, we know that that's not the case. People who commit a crime may have done it for a whole variety of reasons. We've had cases in which people have just gone through a tremendously traumatic experience, and the crime that they are involved in, whether it's a substance abuse related crime or driving under the influence or a battery or an assault, oftentimes can be explained based on this trauma. And what we have found is if we can find the trigger that caused the conduct and address that. So for example, let's say you got into a bar fight because you were at the bar drinking, all right? And we can establish, look, you have a drinking issue. We can help you deal with that through treatment and rehabilitation. And so we take you out of that situation where you're not going to be involved in that kind of conduct again. And presenting all that to the judge and explaining to the judge, look, this person has taken ownership of their conduct and have worked hard to prevent that conduct from happening in the future, can reap great benefits. I've had people who didn't have to do any jail time at all, or could do community service, or only pay a fine, or get to do their time on an ankle monitor, because we were able to put forward their story. Who are they and why did they commit the crime? So it's not just about guilt and innocence, but it's about mitigation.
The full story of what's going on too.
Exactly, it's about
Yeah.
mitigation. Why did you do what you did? We represent service members who have been exposed to some pretty horrendous things. And the fact that they commit a crime, they need to understand, or the court needs to understand who this person is in order to properly sentence that individual.
Yeah, no, that makes absolute sense. So then, Mike, myth number 7 we have here is they didn't have the right to arrest me, but I can't fight the system.
Well, and it's interesting because in this day and age of cell phones and everybody taking pictures of everything, there is a lot more evidence of police misconduct and ways to actually prove that. So, while it may have been true at one time that it was just the police officer's word against yours, that is not necessarily the case anymore.
There's about a video of, I think, everything that happens practically nowadays.
More and more police have body cams and in-car cameras, and other people in the area may be taking pictures. So if a police officer violates your rights, searches you illegally or detains you illegally, oftentimes there is something that we can do to right that wrong. If your constitutional rights have been violated, then there are remedies for that, and sometimes that remedy is that the evidence that they seized is tossed out. The only way to know that, and the only way to be able to put those kind of motions forward, it requires a skilled attorney who understands the law. This is an area of the law that it changes all the time. The Supreme Court changes the rules, the legislature changes the rules, so the ability to actually litigate that and show that the police officers may have violated your rights can be very important. And there's also a strategic advantage to that. If you can put forth a good faith argument that your rights were violated, sometimes the district attorney will negotiate the case away because they don't want to put that police officer in a place where maybe they're being embarrassed or they're shown that they violated your rights. So there are strategic advantages to being able to show that the detention or the stop or the search is at best iffy.
Okay, that makes sense. Thank you very much. All right, here's another one. Judges do not like it if you hire a defense attorney. In fact, they will offer less leniency if you do.
So the exact opposite is true. The court does not like people to represent themselves for some very practical reasons. One, a non-lawyer doesn't understand the rules and doesn't understand the protocol. There is definitely a protocol that needs to be followed in the courtroom, and the court doesn't want someone who doesn't understand those rules. The court a lot of people think that everything in the courtroom is personal. I can tell you, having known lots of judges and having been in a lot of courtrooms for 31 years, what the court is most interested in is moving their calendar along. So if they have a calendar with 40 people on it, they want to move the calendar along. They don't want to spend 30 minutes debating with you, some issue that you brought up. Or trying to explain the rules, or trying to explain why certain things are happening. They want you to have an attorney who spends the time explaining it to you and interfaces with the court. A lot of judges are short. They want you to say the right things at the right time, get in, get out, be done, and off of their calendar. And people who represent themselves often fall into this trap of making the judges mad. So the exact opposite is true. That not only the judge is never going to hold it against you to have an attorney. As a matter of fact, you can bet your bottom dollar that if the judge got in any kind of trouble, he or she absolutely would have a lawyer.
Yeah.
They wouldn't go in and represent themselves, even though they understand how the system works. So no one is ever going to hold it against you to have a lawyer, but it can be held against you if you don't have the good sense to have a lawyer.
So once again, the myth is about the opposite of the reality.
That's right.
So let's shed the light a little bit on hiring an attorney. We found that a lot of people believe that there are hidden costs to hire an attorney. In other words, that the attorneys are going to be misleading them in some way and they're not going to have the full picture, which I'm sure maybe with some attorneys this could be true or not. So how does one make sure, proactive, that I'm going to find the right attorney and they're going to be quoting me everything up front?
Well, and that's a great question, and it's a difficult one to answer from the perspective of a lot of times people come in and they say, I was arrested for, let's say, a domestic violence case, and they want to know how much it's going to cost. There are fundamentally two ways that criminal defense lawyers charge. One is a flat rate, and they'll say, okay, it's $5,000 to do that case up to trial, for example. Now, the problem with the flat rate is somebody is going to wind up on the short end of the stick. So, I've seen situations where you go in, the client comes in, they say, I was arrested, and they're quoted, say, $5,000, and then you show up and the district attorney, for whatever reason, decided not to file. Well, it was a really good payday for that lawyer. He made a court appearance, spent about 2 hours on the case, and made $5,000. Sometimes it works out the opposite. You show up, the case is filed.
Let me back up a minute, because if you didn't have an attorney to show up on your behalf, it never would have gotten, it never would have been dismissed. So it did.
That may or may not be true.
Yeah.
Sometimes it's not filed because the district attorney looked at the case and decided that it wasn't a case worth pursuing. You don't know at the point, once you're arrested, all you know is that they've given you a court date. You don't know what's going on behind the scenes. And it's not uncommon for people to come in, I have court tomorrow morning, or I have court in 2 days, and there's really no chance to interact with the attorney to determine whether it's going to be, or the district attorney to determine whether it's going to be filed. The other side of that coin is if the person charges a flat rate and it winds up going to court over and over and over for a whole variety of reasons, and you're making 10 or 15 court appearances, the attorney is going to get very frustrated because they're not making any money. Okay, they're essentially handling the case for free at that juncture, but they have a contract with you. Our preferred manner of handling cases outside of DUIs is on an hourly basis, which is fair for everybody. So you only pay for the time that people spend on the amount of court appearances that occur. So a $5,000 retainer, if you went to court and for whatever reason the case wasn't filed, or we were able to convince the district attorney to dismiss it or get it resolved very quickly, you would get a refund because that money is just held in trust on your behalf. But the idea of hidden costs, there really shouldn't be any hidden costs. The State Bar requires that there be a written contract, and I know in our contract we talk about the costs of experts, we talk about the cost of investigators, we talk about the cost of consultants, we talk about the cost of going to court, and the various fees that go along with that, and the cost of discovery and copies and all of those things. That should all be laid out in that contract. So while you may not know the final number, it's not like buying a car. okay? You're paying for a lawyer's time, and that time is based on what needs to be done. I've handled cases that on the outset looked very, very simple, and we wound up having to go all the way to the California Supreme Court because the judge refused to follow the law. And that's what the California Supreme Court said. The judge refused to follow the law and made him follow the law. But it took us a lot of time and a lot of effort. On the other hand, we've had cases that we quoted, at a certain rate, and we went in and we got it resolved very quickly, and the clients get a big refund. So there shouldn't be hidden costs. And the other thing is you need to stay in communication with your lawyer. Where are things? You should be getting an invoice every month that tells you where, how much time is being spent, what is being done, and where is your trust fund? How much is left? You should be talking to your lawyer. Are you going to need additional money? I know I typically will, tell the client it's going to be more than I think it will be, because I don't like to, overpromise and underdeliver. If I say it's going to cost $20,000 and it turns out being $5,000, I have a very happy client. If I say it's going to be $4,000 and it winds up costing $5,000, I'm going to have a very unhappy client for the exact same case.
Well, what I'm hearing you saying is that communication is a big part of it, and that you need to understand what it is. You need to understand your contract. You need to read it. You need to ask questions, right, until you really have a full understanding if you're not quite sure.
Absolutely. One, you need to trust your lawyer. Okay, that's kind of the
Number
bottom
one.
line. If you don't trust your lawyer, then the person that you've hired, you probably should go and find a different lawyer, because it's important to trust the person and understand that they're not trying to cheat you. Okay, the lawyer is not trying to cheat; they're trying to help you. But having open communication and asking, well, why did this cost so much? Or a lot of times on a bill you'll see, reviewing discovery, and you may ask, well, why did that take 5 hours? And I'll pull out the box and show you, okay, there's 587 pages here that need to be gone through very, very carefully, because, as they say, the devil's in the details. So understand what your lawyer is doing and what you're actually paying for, which is time, is an important concept. But no, you really should never be blindsided with some giant bill at the end of the day.
Okay, fair enough. Thank you. So our final myth here, or misconception, is that the best attorneys are the most expensive.
And again, that's not necessarily true. Now, the idea that you get what you pay for is a truism. Different lawyers will charge different amounts based on a variety of things. How long have they been in practice? What's their skill level? What's their reputation? How good are they? Someone straight out of law school, you would not expect to charge the same amount as someone like myself, who's been practicing for 31 years and has handled literally thousands and thousands of cases. But on the other hand, you would expect me to be more efficient, so I can get through these cases. I don't have to reinvent the wheel, because very few things are new to me. I've seen all these, information banks and brief banks and such that I can draw on. But having said that, the most expensive lawyers are not necessarily the best lawyers. What you want is someone who is focused on what you need. So there is only a minor relationship between what a person charges and the value that you're going to get. Now, make no mistake, on a serious offense, especially if it's a felony, hiring a defense lawyer is not inexpensive. Okay, it costs money to get the kind of skill sets that you need to represent you, but you don't necessarily need to hire the guy who's driving around a Ferrari and wearing the $8,000 suits. What you need is someone who is well established and solid in the community and charges you a fair rate. So that's really what you should be looking for. It's not necessarily the most expensive, but you also need to be careful about the discount lawyers. The guys who are, this is really the bigger problem, is the guys who will do it super cheap. I'll do your DUI for $500, or I'll do your domestic violence case for $2,000. Well, the truth of the matter is either they're not very good, they don't know what they're doing, or more likely, they're simply not gonna spend the time and resources on your case to give you the best defense.
They're just gonna run you through the system.
They're gonna run you through the system, they're gonna walk you through and plead you out, and they're gonna spend their time trying to get you to admit guilt as opposed to trying to, present a mitigating case or prove that you are in fact not guilty.
Well, that's our 10 myths, and for me, kind of the summary is that you really want to make sure, first off, is to take your charges seriously, no matter how big or small, no matter if you've done it or you haven't done it, and then really finding the right counsel is paramount. And is there any other kind of things you want to tell us in some final thoughts with this, Mike, about, who to hire and why? And, I mean, we covered a lot here.
Well, I think hiring a lawyer for many people can be very confusing. Maybe they've never met a lawyer, or they don't know any lawyers, and they don't really know where to go. I do recommend that before you spend the time of going to a lawyer and sitting down in that person's office, that you Google them, look at their website, see what their peers have said. We have the benefit here of having been selected as one of the best lawyers in the country a number of years in a row. That's peer review. That's other lawyers saying, hey, if I was in a jam, Chastaine's the guy I would want to go to help me out. So you should look at that. You should look at AVO for a rating. Now, none of these things by themselves is the end-all be-all. But to understand that the person that you're going to has good reviews, you can look on Yelp.
Customer reviews.
Customer
on Yelp you'll find those, or
do they treat you well? Are they honest with you? Or do they have integrity? If they make a mistake, will they own up to it? Very rarely, but occasionally we'll make a mistake and we'll own up to it. Sometimes we'll charge something that was a mistake and we'll correct it. We're only people, right? But you have to work with someone that you trust and are willing to rely on, and recognize that they have your best interest at heart. That's the foundation of our practice, is to get our clients the best results. At the end of the day, that's how we pick a victory. Is did we get the client the best result that was available to that particular individual?
Well, I notice you keep using we, so how do you feel about having team or staff with the law firm?
Well,
pros or cons of that?
A huge pro. And this is another thing in choosing your attorney. There's a lot of lawyers out there, particularly criminal defense lawyers, who are solo. And I've been there, I've done it myself. The challenge with being solo is that everything falls on your shoulders. I mean, if you run out of staples, you're the one who's going to go get the staples. You got to make sure there's ink in the printer. You're doing all the work, you're answering all the phone calls. There's only so many hours in the day. What you want to hire is a lawyer who is focused on providing you criminal defense, not worried about whether they can pay the rent. We use the team approach here, and I think that that's really critical. We have paralegal, we have associate attorneys, we have a full front office staff. So when you call this office, a human being will answer the phone and find out what they can do to help you, and then pass that message on, either help you themselves, a lot of times they can, or pass that message on to the person who can in fact help you, and then make sure that they get back to you the same day, or at the very latest the next day. Having that whole team concept allows multiple eyes on any problem. So it's, as they say, 2 heads are better than 1. I think 4 heads are better than 1. When we have difficult legal issues that come up, we put it all up on the whiteboard. We have our whole legal team come in and talk it over and come up with the best possible strategy. Sometimes that's thinking outside the box. Sometimes that's a classic strategy. But having a team is really critical, and you want to hire a team. So when you go into the firm, now you've done your research, you've looked at Google and Yelp and whatnot. Now you're going to meet this individual. Who is their team? Is it just one guy in a little broom closet who's trying to juggle 16 things at a time? Or is it somebody who can actually take your case, spend the time on it, and give you the service that you need? You know, a lot of times we find that the legal process not only is complicated, sometimes it's difficult to explain, so you have to explain it multiple times. You know, and this would be like if you were trying to, you know, talk to me about, you know, electronics. I'm probably not going to get it on the first uptake, so you're going to have to explain it to me a couple times. I get this with my web developer and whatnot. He's trying to explain to me why my website should do whatever. And I'm like, I got it, no, I don't have it. Well, the law is similar to that, and so you need to have someone who can take the time to explain it to you. In the courtroom is not a great way to do that. You know, it's one of the challenges that public defenders have, is they don't have a lot of time, so they're trying to, you know, jam all this information to you, you know, whispering in the back of the courtroom. That's not how we do things. You know, I've been a public defender. I was a public defender for over 15 years. I understand how it works. I understand why it works that way. But for the best outcomes, you want to be able to sit down in your attorney's office, have a cup of coffee, take your time, and make sure that you understand what's going on so you can make the very best choices. And the only way you can do that is with a firm that has a team, and that has an office, and that is set up in such a way so that they have the actual time to spend with you to get you the best outcome that's available.
That's great, Megan. What's the #1 complaint with the bar?
#1 complaint with the bar is failure to communicate with your client. So we understand that, and we want to make sure that our clients always know that we are here for them, to make sure that whatever comes up, we can address that in a timely manner and give them the best possible options to move forward.
That's great. Well, thank you so much, Mike. It's a pleasure talking with you today.
As always.
I appreciate your excellence in service and perspective that's based on so much knowledge in this area. And thank you for sharing that with us.
You're very welcome.